Hello, my name is Wolfgang Kerber, and I would like to welcome you to my brief presentation about the topic consumer data rights and competition. In the broad policy discussion about the challenges of the digital economy, we are still struggling with the problem that different policies as competition policy, privacy or data protection law, consumer policy, IP law and other policies try to analyze and remedy the manifold new problems based upon their own specific approaches without looking at the broader picture. But we increasingly understand that in the digital economy often one policy alone is not capable of solving the problems anymore due to the systemic character of digitization, and that it is therefore necessary to have a much more integrated policy approach for dealing with these challenges. Therefore, I very much welcome that the Competition Committee of the OECD initiates this discussion about the relationship between competition policy and the policy for protecting privacy. I also welcome the approach in the OECD paper to use the concept of consumer data instead of the legal concept of personal data in privacy laws, because this allows for a much better and broader analysis of the role of data that are collected about consumers. And these analyses can then be focused on different objectives as competition, privacy, and how consumers can control the data, as well as the availability of data for innovation in the digital economy. And built upon this broad concept of consumer data, it can be asked, what rights should consumers have with regard to their data? In that regard, we can apply from an economic perspective a bundle of rights approach to consumer data derived from the old economic theory of property rights in order to develop a suitable approach to the governance of consumer data. Such a consumer rights approach on consumer data can include the set of rights that consumers are granted through the privacy laws of their countries, also fundamental rights to privacy, as well as rights on their consumer data that are conferred to them outside of privacy laws, for example, through other laws and specific regulations. For example, data portability rights as a specific consumer data right can be granted through privacy laws, as Article 20 GDPR, but also through other regulations, as in Australia through direct legislation about consumer data rights, or in the European Union through the Second Payment Service Directive for opening bank account data. It is important to note that such a bundle of rights approach to consumer data need not only include rights for consumers on the data, but can also include rights of other firms to get access to certain kinds of consumer data, for example, for entry into markets and as input for innovation and AI applications. From an economic policy perspective, we can therefore ask who should have what rights on consumer data and for what purposes. And this can be analyzed with regard to privacy, competition, innovation, including the trade-offs between these objectives. In the following, I will use the example of the governance of consumer data in connected cars, which was one of my research projects in the last years and is a topic in one of the boxes in the paper. Since 2016, we have a very controversial policy discussion in the European Union about the so-called extended vehicle concept of the car manufacturers in Europe. They have designed connected cars as an IoT device in that way that first, all data that are produced in the car are directly transmitted to their own proprietary servers. And secondly, they also have exclusive control of the technical access to the car, that is, the car is designed as a closed system. Through this exclusive control of the in-vehicle data and the access to the car manufacturers are in a monopolistic gatekeeper position that allows them to control the entry to all secondary markets in this ecosystem of connected driving, at least as far as these services need access to either these data or the car. From a competition policy perspective, the huge concerns of independent providers of services are justified that this gatekeeper position allows the car manufacturers to leverage market power and foreclose competitors on these secondary markets, which can lead to harm to consumers through less competition, innovation, and less consumer choice. The policy discussion refers to the question whether the EU Commission should ensure that the independent service providers get access to these in-vehicle consumer data for protecting fair and undistorted competition on these secondary markets. This problem is directly linked to the current competition policy discussion about facilitating access to essential data for avoiding leverage and foreclosure effects on secondary market, especially also with regard to the many new emerging IoT ecosystems. This data access problem is also addressed explicitly in the current proposal of amending German competition law. Since the gatekeeper position of the car manufacturers is based upon the exclusive control of these consumer data, a regulatory approach that ensures a non-discriminatory access to these data, also for independent service providers, for example through a shared server concept, and/or ensures that the consumers remain in control of their consumer data, for example through the introduction of open interoperable telematics platforms that would allow the consumers to decide whom they grant access to their consumer data, can help to solve the competition problem, allow for more data-driven innovation, and give the consumers more control of their data, also in respect to their privacy. This is right now an open policy question in the EU, and one option would be to extend the already existing France-like access regime to essential information for repair and maintenance services in the motor vehicle type approval regulation to all in-vehicle data that are necessary for new services in aftermarket and complementary services in this IoT ecosystem of connected driving. In my last part, I want to focus on the main question in the OECD paper. Should competition law take into account effects on privacy, for example in merger cases or in market dominance cases, as in the very controversially discussed Facebook case of the German Bundeskartellamt? And if yes, how? It is clear that from a competition law perspective, privacy and the extent of the collection and use of consumer data can play an important role in competition law, both with regard to its effects on competition and with regard to its effects on the welfare of consumers, which certainly includes privacy risks. And this can be relevant in merger cases, cartel cases, and in dominance cases with respect to exclusionary and exploitative abusive behavior. First, I would like to emphasize that the OECD paper very well discusses and analyzes in that respect the existing case law about mergers, abuse of dominance, and cartels, and in particular also the manifold problems of how to apply competition law to privacy and the collection of consumer data. I would also have very much liked to comment and add to this discussion. However, I want to do something different. The main critique of the Facebook decision of the German Bundeskartellamt is that the protection of privacy is a task of data protection law and not the task of competition law. Therefore, competition law should focus only on protecting competition, and attempts to protect also privacy would go far beyond the proper scope of competition law. With this critique, we are right in the middle of the debate about the relationship between competition law and data protection law, or the division of labor between both policies. In the following, I want to offer some hints how this relationship can be analyzed from an economic policy perspective and what conclusions might follow from that. My starting point in this analysis is that in many competition cases where we are discussing competition problems with respect to privacy and the collection of consumer data, we are dealing with the problem of the simultaneous existence of two market players, as for example also in the Facebook case. We all know, and is also broadly discussed in the OECD paper, that due to information asymmetries and behavioral problems of consumers, which are aggravated through intransparency and hidden data collecting strategies of firms, the consumers are overwhelmed and are often not capable of making well-informed and rational decisions about giving consent to the processing of their personal data. Therefore, this market for consumer data suffers from a market failure problem and is usually seen as a task of data protection law and consumer law to deal with this market failure, for example by requiring transparency and by prohibiting misleading and manipulative strategies of data collecting firms. Now, my main point is that it cannot be expected that the effects of these two market failures are independent from each other. On the contrary, we have good reasons to expect that interaction effects between these two market failures exist. That is, that competition problems might lead to less transparency and to a larger market failure problem through information asymmetries, and that at the same time also more intransparency and misleading behavior of firms might lead to more competition problems. For example, information and behavioral problems might also be the reason why so far privacy-enhancing competition, leading to more privacy-friendly policies about the collection and use of data, does not work effectively. However, if these two market failures exist simultaneously, and there are interaction effects between both market failures, then it's clear from a theoretical perspective that both policies cannot ignore the effects of the other market failure. This implies that competition policy has to take into account in its decision on competition first that there might be effects from the second market failure, also in respect to competition, and also secondly, whether and to what extent data protection and consumer law can remedy some market failure through information and behavioral problems. This last point refers to one of the results of the analysis of the EU case law in the OECD paper, that in several competition cases the EU Commission has relied too much on the effectiveness of data protection law, for example, in preventing the combination of data sets in merger cases, or also with respect to the effectiveness of the data portability right. Therefore, the application of competition law has to use a realistic view of the conditions on the market that also includes the other market failure and the current limits of the effectiveness of data protection and/or consumer law. However, vice versa, such an approach of looking at both market failures would also encompass the question whether competition problems should also be taken into account in the application of data protection law. There is some discussion whether the fact that a firm is dominant might be relevant for assessing the validity of consent in EU data protection law, but this is so far no criteria in data protection law, and it's very unclear whether enforcement agencies of privacy laws could carry out such a competition analysis. However, as long as we use a consent-based model in privacy laws that leads to a market for privacy and the collection of consumer data, it is clear that such a market can only work well if we also have effective competition on this market. Mergers, dominant positions, and cartels can endanger this competition, and privacy laws cannot ignore these competition problems, at least as long as they are relying on such a consent-based model. Since it cannot be expected that privacy law regimes can solve these competition problems, it is the task of competition policy to solve these problems. What conclusions can be drawn for the relationship of competition law and data protection law? First, in cases of a simultaneous existence of both market failures, we might need the application of both policies for solving the problems. And this is not surprising from an economic perspective. And it is primarily not a question of either competition law or data protection law. Second, in addition to that, each of these two policies cannot only focus on their own market failure problem, but might also have to consider the other market failure and the effects of the other policy. Third, more research is necessary about the interaction of both market failures and the aggregate effects, and the interaction effect of both policies, for example, competition policy on privacy and privacy policy on competition. A discussion of some of the already existing research can be found in the OECD paper, but we need much more research. Fourth, necessary is a development of a more integrated policy approach, asking for sophisticated combinations of competition law and data protection law remedies. And lastly, fifth, such an integrated approach would require cooperation of the enforcement agencies of competition law and data protection law, and also consumer law, and perhaps also a large alignment of the laws themselves. I know this process of cooperation between competition and data protection authorities has already started, and I'm also glad that the importance of this insight is also emphasized in the OECD paper. On this last slide, some references to background literature on these issues can be found. And I would like to thank you very much, and I'm looking forward to our discussion at the round table.